Hello everybody and welcome to another episode of LJ Law, Family Law TV. I am Bonnie Leonardo, your host. Today's question comes to us from Danielle, and her question deals with her family pet. Her and her husband purchased a puppy right after they were married, and now they are going through a divorce and are having a battle as to who the puppy or the dog will go with now. Before I get started with that question, I want to remind you that if you have questions about this topic or any other family law topic, please don't hesitate. Go to vegasdivorcemeeting.com. I'll be more than happy to sit down with you to discuss your particular situation. So, as I stated, Danielle's situation is this. Her and her husband were married 10 years ago. At the beginning of the marriage, they purchased a puppy. Danielle really wanted a puppy. They're not able to have children. And so she purchased a puppy during their marriage. And this puppy, as most of you know, is very emotionally attached. Danielle is very emotionally attached to the dog. The dog is part of their family. It is not considered a dog, but an extension of their family. This is like Danielle's baby. She cares for this dog. She receives a lot of emotional support from this dog. She goes everywhere with this dog. She's very, very bonded with the dog. Now the couple are going through a divorce, and her husband is stating that he wants custody of this dog. Danielle is asking me, how can that be when I purchased a puppy and it is my dog? So unfortunately, even though most people have an emotional attachment to their pets and they are considered part of the family, Nevada law does not see it that way. Nevada law sees an animal as part of community property. It is property to be equally or equitably divided upon a divorce. Therefore, because of community property laws, this dog is owned equally by both parties, 50-50 shares. So when a court is dividing assets and debts in a divorce, an animal, in this instance their dog or Danielle's dog, will be considered to be property that will need to be equal or equitably divided. That being said, the court does listen to testimony about one party being more bonded and taking care of the animal than the other, and it might take that into consideration when dividing the property of the couple's marital estate. And in this situation, if Danielle is able to prove to the court that she in fact was the one bonded with the animal, was the one taking care of the animal, and the spouse was not, there might be an offset in division of property to equal that of Danielle getting the dog. But for the bottom line, in Nevada, your pets are considered property that are subject to equitable or equal division during a divorce. I hope that this answers this question. If you want to discuss this a little bit further, please go to vegasdivorcemeeting.com. I'll be more than happy to sit down with you to discuss this question with you. And if you like the video, please hit the like button. And if you know someone who can benefit from this information, please share this video with them. And as always, I want to thank you for tuning in, and I will see you next time.